to welcome everybody that's here virtually, as well as a lot of people who have dialed in. It's great to have everybody show up. This is public records training, open meeting law, conflict of interest, and meeting minutes training, so that we write minutes, not seconds. Greg Corbo, Town Council, is here tonight, and he's going to be covering most of the presentation. This training provides you with an overview. It's geared to newly elected officials, as well as a refresher for some of the people who've been on the boards for a long time. It's also geared towards the staff that end up being the ones that have to keep us all on track and make sure everything gets done. So for the admins that are here, thank you for doing that. This doesn't replace the specific training that the state will require, but it does offer a chance for you to ask questions and to sort of hear about Sterling-specific issues that might be on your mind. So with that said, I'm going to turn it over to Greg, and we'll go from there.
Yes.
Do you want people to hold on their questions or as you go?
I'd rather do it as we go, so I'll explain that.
Okay, good.
Good. I don't know where to look.
This is where the camera is.
Okay. Good evening, everyone. For those of you who don't know me, my name is Greg Corbo, Town Council, and I'll be leading you through the training this afternoon. I've done this training at least 100 times, but never quite in this way. So please bear with me if we stumble through the procedure a bit. I'm going to go through this, I guess, relatively quickly. This is really intended just to be an overview, but I'm happy to take specific questions, Sterling-specific questions, as Ross mentioned. So if you do have a question, feel free to raise your hand, and we'll try to get your question heard. I'll rely on Ross for that, since I can't see, since the camera and the screen are on opposite ends of the room for me. So I can't look in both directions at the same time. As you ask your questions, I just would suggest that your questions be phrased in the form of a hypothetical, rather than specific to a particular situation which may or may not have happened. This is an educational seminar. It's not meant to catch anyone or discipline anyone who may have made mistakes in the past. There's nothing we can do about that at this point, but what we can do is try to get better going forward. So the way I'll go through this, hopefully everybody has a copy of the PowerPoint presentation, either on their computer or printed out in front of them, and I'll go through this one slide at a time. And as I said, if you do have specific questions or something that you want me to cover a little bit more in depth, I'd be happy to do that. One new aspect of this presentation, which I haven't covered before, are some of the COVID-specific procedures, which we'll probably want to spend a little bit more time on, since that's something that is likely not going away anytime soon. So with that, I'll just jump right in. So slide number 1 is just a general overview. So
Slide number 1, that was a clue for me to do something.
yes. Is there a remote? Okay.
Here we go.
Okay, we skip over that. Okay, so this is just the general overview. What we're talking about here, they refer to as sunshine laws, because they're intended to shine the light on the operations of municipal and state government. So we have the open meeting law, which governs meetings of public bodies. We have the public records law, which governs documents and other materials made and received by public officials. And we have the conflict of interest law, which addresses the standard of ethics for public officials. So the first thing we'll start with is the open meeting law. And in particular, what types of meetings are subject to the law and why, what rules need to be followed in order to hold a meeting, and what are some common pitfalls or violations that you want to look to avoid? Okay. So the open meeting, we start off with general definitions. So there are 4 main definitions here that you need to be aware of. First, the definition of a meeting, which is a deliberation amongst a quorum of a public body to discuss matters within that body's jurisdiction. A deliberation is an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body on any public business within its jurisdiction. A quorum is a majority of the full complement of the members of a board or public body, except in limited circumstances. And a public body is any multiple member board, commission, committee, or subcommittee within any city, region, town, etc., however created. So the key takeaway here is that if you are on a multiple member board, you cannot discuss any business within the jurisdiction of that board with a majority of members in any type of forum unless you're in a duly posted public meeting. So that includes emails that may be received by a quorum of the board, posts on social media that may be participated in by a quorum of the board, phone calls, impromptu meetings that may occur in public places. All of those things you should avoid and reserve for meetings that are held with proper posting and in a public place under the open meeting law. Now, in addition to formal public bodies like the Board of Selectmen, Board of Health, Conservation Commission, Planning Board, there are also less formal bodies that may be formed, which we refer to as subcommittees. And a subcommittee is a multiple member body created to advise or make recommendations to a public body. And it's often difficult to figure out when a subcommittee is subject to the open meeting law and when it's not. It doesn't necessarily turn on what the committee is formed to do. And a committee that is purely advisory can also be considered a subcommittee subject to the law. It depends more on how the committee is formed and the way in which it's permitted to act. So anytime a multiple member body creates another body to advise it or to provide it with information, then that body is also subject to the law. Whereas if an individual is authorized to make decisions by themselves, they can choose to bring together however many people they want, and they are not subject to the law. So, for example, let's say that you want to do an overview of your bylaws to decide what bylaws should be modified, which ones are outdated and can be gotten rid of, or what new bylaws need to be brought to the town. If the Board of Selectmen were to take a vote and direct the town administrator to convene a bylaw review committee and submit a report and recommendation, then the bylaw review committee created by the Board of Selectmen is subject to the open meeting law because the Board of Selectmen was subject to the open meeting law. If, however, the Board of Selectmen said to the town administrator, we want you to conduct a review of the bylaws and issue a report and recommendation to us, then the town administrator can go out and the town administrator can gather together all of the department heads, gather together members of the public, and none of that deliberation is subject to the open meeting law because the town administrator as a single person is not subject to the open meeting law, and therefore no group he brings together is subject to the law. So is that the distinction understood? Okay.
Yes.
Thank you. Okay. So moving on, once we've determined that you are a public body who is subject to the open meeting law, there are 3 general requirements for going forward with a meeting. You've got to have proper notice. you've got to be meeting for a proper purpose, and you have to maintain minutes. So with respect to the first part of this, the notice has to be properly posted with the town clerk. It must be posted in the proper location, and it must give the proper level of detail. With respect to the purpose of the meeting, there's a presumption that all meetings will be open to the public unless they fit within specific defined reasons that a body can go into executive session. And you must keep minutes of all of your meetings, including executive session meetings. And those minutes have to have the date, time, location, members present at the meeting, as well as a description of the topics discussed at the meeting. And we'll talk about specifics of minutes as we go along. So with respect to what constitutes a meeting, as I said earlier, any deliberation amongst a quorum of the business of that body. However, there are certain exceptions to that rule. So the first exception is distributing meeting agenda or other scheduling information. So it's perfectly fine for all of the members of the board to be on an email chain or be communicating by telephone or text messages about the time or location of a meeting. Can everybody make a meeting next Wednesday? Should we hold our meeting at the town hall, or should we meet outside? All of those things where you're not discussing the substance of the meeting are fine for discussing amongst a quorum. The same thing with respect to distributing materials that you intend to discuss at a meeting. Here's the report of the town administrator with respect to his review of the bylaws. We're going to talk about this at our meeting next Tuesday. That's perfectly fine to do. What's not fine to do is to say, here's the report of the town administrator. I think that his first 5 recommendations should be adopted by the board, but the second 5 should not. Well, by interjecting those opinions, now you've engaged in a deliberation. So, when you're using this exception, you want to be careful to limit it to, here are the materials that we're going to discuss at our next meeting. The other thing is attendance at an on-site inspection. This would not constitute a meeting as long as there is no deliberation amongst members of the board. So you'll frequently see this, say for example, with the Conservation Commission or the Board of Health. They may need to go out to a site to look at the conditions, and all of the members, they can go out there, they can walk around, they can look, but they can't talk about what they're seeing. So what we typically recommend is that you schedule a site visit, and then soon thereafter, even the same day, you come back to town hall and you hold a meeting so that you can talk about what you saw. The other thing that doesn't apply as a meeting is attendance at a public or a social gathering, as long as members of the board do not discuss business amongst themselves, and also attendance at a posted meeting of another board or committee if that other board or committee has posted their meeting, and again, you don't have a deliberation amongst yourselves while you're in attendance. So for example, we had a case once where there was a meeting of the Board of Selectmen with respect to the annual budget. And the members of the school committee appeared and sat in the audience, and when the selectmen were started talking about the school committee's budget, they all went out into the hallway, whispered amongst themselves, came back in, and then one of them raised their hands to make a comment. And what the Attorney General found was that that was a violation by the school committee. Even though they were authorized to be there, they weren't authorized to go out and talk amongst themselves and reach a consensus about what they would say in public participation. So if you are going to attend a meeting of another board and you think it might be necessary for your board to also deliberate, best practice would be to have your board post a meeting as well, or post it as a joint meeting. So, you can post a joint meeting of the select board, the finance committee, and the school committee. This way, all of those boards are covered and they can all deliberate in that same session.
And that only needs to be one posting for those 3 boards or whatever.
That's correct. It can be one posting as long as you list all the boards and all of the topics that are going to be discussed. Yes?
I have a question, Greg. We do a lot of sidewalks. I'm part of the Conservation Commission. And so I'm hearing that now deliberations can't take place on that site. Can we book the meeting in the site at the same time?
You cannot book the meeting at the site because in order to have a meeting, it has to be in a location that is open to and accessible to the public. And chances are when you're on a site visit, first of all, the property owner can refuse to admit people so that it wouldn't be open to the public. And second of all, it's not likely that that site is going to be accessible.
Okay. Thank
Okay?
you.
Okay, so any other questions about what constitutes a meeting?
Yes, I have a question. If the finance committee individual members are tasked with meeting with other boards or departments to discuss budgets or capital or whatever, does that need to be a posted meeting?
As long as it's less than a quorum attending each of these interview sessions, then no, it does not have to be a meeting.
So if it's one finance member, but a quorum of, well, if you were meeting with a department, like the police department or whatever, this doesn't apply to them?
That's correct. So let's say that you're a member of the finance committee and you each sort of divvy up responsibility for meeting with the department head. So one of you is going to meet with the police chief. One of you is going to meet with the DPW director. One of you is going to meet with the facilities manager. One of you is going to meet with the school superintendent. Each of you can go out and attend that meeting and take down whatever information that you want. That meeting between you and someone else does not have to be posted. It does not have to be open to the public. However, when you report back to the finance committee your results, then that has to be done at a meeting of the finance committee.
And what if, say, you were meeting with the school board to discuss budget concerns? If they had a quorum of their board, that would have to be posted?
That's correct. So if you were meeting with a quorum of the school board, then the school board would post a meeting, and one of their agenda items would be meet with finance committee concerning FY22 budget.
Okay, great.
Yes,
Can
sir.
I ask that since we can't see who's asking questions, if the clerk could announce who they are?
Yes. Ma'am, would you mind announcing who you are?
Ms. Mary?
It's Mary Clyde.
I did not say anything, Maureen.
That wasn't you?
That was not me.
There was Lynn Shepherd.
And, yeah,
Thank you.
Sorry, I unmuted myself. Can you hear me?
Yes. Okay, thank you, Ms. Shepherd. Yeah, so for the benefit of everyone, sitting here in the room, we can't see where the questions are coming from. So if you could just state your name before you ask your question, that would make things easier for us. Okay, so moving on then, with respect to email, I covered this briefly. Email is a very difficult trap for the unwary, and it's really recommended that, even though email, text messages, social media is definitely part of the fabric of our lives at this point, when you put on your town official hat, try to forget that it exists, because it can only lead to difficulties for you. You may send something that you think is relatively innocuous, and then 2 other members start to join in a conversation, and now all of a sudden you're talking about a matter of substance, and you've had a meeting over email, even if you didn't attend to it. Text messages, the same thing. Even social media groups. If somebody is participating in an online community forum, and you have one member of a board chime in on a topic, and then another member of the board responds, now all of a sudden those two members have had a deliberation. So, it's difficult because, again, it is such a focus of our lives, and, in your private business, everything is done over email and text message. But, to the extent that you can avoid it for substantive town business, you should do that. The other thing you should bear in mind is that everything that you do via email, text message, social media post is a public record. And so what we always say is that if you're not willing to see your email printed on the front page of the newspaper, don't send it. Okay?
There's a few people who could tell us. Just the one that you have on here.
All right, so I think we can now skip ahead to before the meeting notice and agenda.
Yeah.
Okay. Okay, so now we're going to talk about the mechanics of how you hold a meeting. And the first step of this is to post notice of that meeting with the town clerk. The meeting notice, or that's more commonly referred to as the agenda, has to be posted at least 48 hours prior to the meeting, not counting Saturdays, Sundays, and legal holidays, except in the case of emergency, which we'll talk about in a bit. The meeting notice has to include the date, time, and place of the meeting, as well as a listing of topics that the chair reasonably anticipates will be discussed. Each agenda item has to be listed with sufficient detail so that a member of the public can look at that agenda item and have an understanding of what the nature of the topic is going to be. So, for example, if you're meeting to discuss whether or not a certain proposal should be brought forward at town meeting, you should specify in the meeting notice discussion with respect to proposal to amend conservation or wetlands bylaw, so that people have sufficient notice to say, okay, the Conservation Commission's going to be meeting about changes to the wetlands bylaw. That's something I'm interested in. That's a meeting that I want to attend. What is strongly discouraged is very open-ended topics like new business, old business, matters not anticipated, things like that, because that doesn't really give people enough information as to what's going to be discussed. So you want to try to have, enough detail in there so people can have an idea of what you're talking about. Now, if you have a meeting notice that's already been posted and something else does come up within the 48 hours, if that is a matter that the chair could not have anticipated coming up, then the board can still talk about that agenda item, provided that they update the meeting notice as soon or as long as possible before the meeting. So, if you're having a meeting on Monday and on Friday, the chair gets notice that a lawsuit was filed against the town, and it's something that the board needs to make a decision on relatively quickly, they can amend that meeting notice to reflect discussion of that litigation. And when they do the amendment has to specify the date and time of the amendment and the new matter. And when you talk about that matter, it's advisable that on the record, you disclose the fact that, we just learned about this on Friday. We didn't think it could wait until our next meeting. We updated the agenda as soon as we could, and that's why we're going to consider this. But what the Attorney General would say is that if something can be postponed to be discussed at a properly posted meeting, you're encouraged to do that. The other thing is that if you have a public comment period during your meetings, you can respond to those public comments even if they're not in the meeting notice. But again, you're encouraged not to respond, but rather to say, that's something we want to talk about. We're going to put that on the agenda for our next meeting. Do we have questions about meeting notices or timing?
No.
Okay. Okay, so we talked about that. Okay, so before we get into remote meetings, one more thing I want to say about meeting notices is that they also have to include notice of your intent to go into executive session. And in the meeting notice, you have to include not only the fact that you intend to go into executive session, but the reason, stating which of the exemptions that you intend to use, and stating as much detail in the notice as you can without ruining the purpose of the executive session. So for example, if you intend to go into executive session to discuss litigation, you would say executive session with respect to litigation strategy, and you would specify in the case of Jones versus the town, if discussing the matter in open session would have a detrimental effect on the town's litigating position. If it's real estate, you would say enter executive session for the purpose of discussing the value of real property with respect to the location at 52 Main Street. The only time you would be exempt from that is if disclosing those details in and of itself would ruin your reason for going into executive session. So for example, if you were planning an eminent domain taking of a property, publicizing that to the world may not be in your best interest at that time. So you wouldn't necessarily have to disclose the property address. Likewise, if you're going into executive session to protect the privacy of an individual, you're not going to name the individual in the executive session notice, because then that in and of itself is compromising their privacy. So again, you disclose as much information as you can, but without ruining the reason for the executive session itself. Okay? So questions about that? All right, so why don't we talk a little bit about the state of emergency and conducting remote meetings. Ordinarily, a meeting has to be held in a public place that is open to and accessible to the public. Under the orders of the governor, however, there are certain exceptions to that, provided that you follow the prescribed procedures. So first off, public bodies are now no longer required to hold their meetings in locations that are open to the public, provided that the public body makes provision to ensure public access to the deliberation of the public body through adequate alternative means. So what this means is that there must be measures to provide transparency and permit timely and effective public access to the deliberations of the body. Those means may include providing access through telephone, internet, or satellite-enabled audio or video conferencing, or other technology, and that allows the public to clearly follow the proceedings of the public body while those activities are occurring in real time. So if your meeting is broadcast live over cable access, that is a sufficient means of alternative access for the public. Having these types of Zoom meetings are acceptable as long as you sufficiently publicize the procedures for people to join in and watch the meeting. As with any other meeting, you're not required to allow public participation. So, if you're not having a public hearing and you're not anticipating having a back and forth with members of the public, simply broadcasting it over cable access would likely be sufficient. If, however, the public does have a right to participate, then all members of the public have to have an equal right to participate, which means that they have to be able to do so in a way that they can speak with the board and be heard by other members of the public. So in that case, broadcasting over cable access by itself wouldn't be enough. You'd have to also have some means for members of the public to either call in by phone or participate in video conferencing. With respect to the members of the body itself, the members of the body can all be present physically in the room. Less than the full complement of members can be present in the room, and some can be participating by video, or all members can be participating by video. The other nuance is that with respect to participation or attendance by members of the public, if you are meeting in a public place, you are allowed to have members of the public attend in person, but only if you have enough room for everybody who wants to attend. So the governor now has strict rules on how many people can be in a public place at a time. I believe it's 8 people per 1,000 square feet and up to a total of 25. So you may think, well, we don't usually get a whole lot of people coming to our meetings. We can meet in person and we're not going to broadcast over the internet. Well, you know, you've got, let's say, 3 members of your board, and you have a small room and 5 other members show up, and then a 6th person wants to walk in. Now you're over the governor's occupancy limits, and you're not allowed to continue on with the meeting. You can either move the meeting to a bigger location, or move it outside, or postpone to another time. But what the Attorney General has made clear is that you can't allow some members of the public to be here live and require that other members of the public watch remotely. They can choose that, but if you're going to allow anyone to be here in person, you have to have enough room for everyone to be here in person. Okay? Okay. Otherwise, once you're conducting your meeting by virtual means, all of the other requirements of the open meeting law apply. So you've got to post your notice 48 hours in advance. The notice has to contain a listing of the topics that you anticipate will be discussed. In addition, the notice has to have a description of how someone can see and or participate in the meeting. All votes done at a virtual meeting have to be by roll call. Even if they are unanimous votes, you still have to take a roll call vote. You still have to keep minutes. You're still limited to the topics that are addressed in the meeting notice. So any other questions about virtual meetings or the state of emergency? Yes, I have someone in the room.
Does it have to be, Patty Page, does it have to be a video at all times, or can a teleconference work?
Teleconference is fine. It does not have to be video unless, no, sure, I understand, right? There are limits. The only time it would have to be video would be if you were using visual aids. Then people at home would have to be able to see those visual aids as well.
I have a question.
Yes.
So you told me it was eight people per 1,000 square feet are allowed into a meeting area?
Yes.
So this room actually can hold up to 12.
You good?
You can't leave, Greg. Don't be counting.
No, I'm counting square footage, there's about just about 1,000, yeah. Yeah. Okay, so I'm trying to figure out our meeting room, how much we can fit up there. It's about the same size.
Yeah, so, I mean, if it's close and you're not sure,
Yeah.
your best bet is to continue to meet remotely. You know, even if your board members want to be present, still broadcast it out there for the public. Other questions? Okay, real quickly on recording meetings. If the meeting is being recorded, whether it's being recorded formally or informally by a member of the public, the chair has to make an announcement that the meeting is being recorded. You know, this goes back to the wiretap statute that you can't record someone without their knowledge. So, you know, typically the chair will make an announcement. This meeting is being recorded and broadcast live over Sterling-Lancaster cable television. Is there anybody else in the room who would like to record? If someone raises their hand, then the chair should acknowledge Mr. Smith intends to record the meeting. Any member of the public in attendance has a right to record the meeting as long as their recording equipment does not interfere with the conduct of the meeting itself. Okay, so executive sessions. As I mentioned earlier, there are only certain reasons for which a public body can enter executive session, and in order to do so, the procedure has to be followed. So, as I mentioned earlier, the first thing you have to do is have the anticipated executive session be in the meeting notice. Once you get into the meeting, now there needs to be a specific motion to go into executive session. Now, even if the only thing you intend to talk about that day is what's on the executive session, you still have to open your meeting in open session and take a public vote to go into executive session. And what the Attorney General requires is that you put something in the meeting notice that the only thing you're going to be discussing is the motion to go into executive session, so that people understand that it's not going to necessarily be a regular meeting. So then what you'll do is you have to, in your motion, state all of the subjects that may be revealed without compromising the purpose of the executive session. The vote to go into executive session must be by roll call vote. You have to announce whether or not you will be reconvening an open session or whether that effectively ends the open session portion of the meeting. Once you're in executive session, you still have to maintain documents that you use. You still have to maintain minutes. You can only discuss matters that are cited in the executive session motion, even if it's a proper subject for executive session. If it's not in the motion, you cannot discuss it in that particular meeting. All votes taken in executive session must be by roll call votes, and you do have to keep minutes. So the purposes for executive session are to discuss reputation, character, physical condition, or mental health rather than professional competence of an individual, or to discuss discipline or dismissal of, or complaints or charges brought against a public officer, staff member, or individual. This is the so-called right of privacy exemption. If you were to use this exemption, in addition to the normal procedures, you also have to provide written notice to the person who you will be discussing. And if it's complaints or charges brought against a public officer, that person has the right to attend the executive session with their attorney and to make a recording of it. That individual also has the right to have their matter discussed in open session if they choose. The second is to conduct strategy with respect to negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel. So with respect to this, you can go into executive session to discuss your negotiating strategy. You cannot actually go and negotiate with the other side in executive session. And once an agreement is reached, that agreement has to be voted on in open session. Under number 3, strategy with respect to collective bargaining or litigation, if an open meeting will have a detrimental effect on the bargaining or litigating position of the public body, and the chair so declares. Again, this is to protect negotiating strategy, so you can't bring the other side into executive session with you. So oftentimes what public bodies will do is they'll talk about their negotiating strategy or their litigating strategy in executive session. Then maybe they'll designate one person to go and sit and negotiate with the other side and bring something back to the board to discuss in executive session. But you can't negotiate with the other side in executive session. Likewise, number 6, purchase, exchange, lease or value of real property, the same rules would apply. So some practical issues for executive sessions. Again, it must be listed in the meeting notice, and your vote must include all of the information that is required, including any declarations that must be made by the chair. So are there any questions about executive sessions? Okay. Next topic is meeting minutes. Okay, so the meeting minutes have to contain the date, time, place of the meeting, and the identity of the members who were present or absent. They must also include a detailed summary of the discussion of each topic, sufficient to allow a person not present at the meeting to understand the substance of what occurred at that meeting. Now, there's often a lot of confusion about this, and it's very difficult to figure out, well, where do you draw the line? It's very clear that the open meeting law does not require a verbatim transcript or anything close to it as to what each and every person said at the meeting. But by the same token, you've got to have enough detail so that somebody can look at these minutes and have a general understanding of what went on. And, sort of a general rule of thumb is, if you've had a 2-hour meeting on something, 1 or 2 sentences probably isn't going to be enough. You're going to need a bit more detail than that. But otherwise, a general summary of what went on is enough. So, if you're the finance committee and you're reviewing town meeting articles, the finance committee discussed Article 2 with respect to a prospective purchase of a new fire truck. The committee members discussed the costs of the truck versus the costs of continuing to try to maintain the existing truck. There were questions from the audience as to what type of truck was purchased. At the end of the discussion, there was a vote 7-0 to support the article at town meeting. The Finance Committee next discussed Article 3, purchase of a new sander. And the same thing, just sort of a short summary of what was discussed, and then identify the vote that was taken. If you have a recording assistant, the recording assistant can make an audio recording of the meeting so that they can go back and listen and make the minutes reflect what happened at the meeting. And then once the draft minutes are done, they can throw that tape away or they can tape over it. It's not something that is required to be saved. It's not an official part of the meeting. Only the minutes are the official record of the meeting. The only exception to that would be if at some point in between the creation of the draft minutes and the making of the recording, if somebody actually requests that recording before it's destroyed, then it is a public record and it must be made available. But the steps are, so you have a recording. Once the recording is turned into draft minutes, the recording can be thrown away. Then you have the draft minutes. Once the draft minutes are approved by a vote, then the draft minutes can be thrown away. Again, unless there are intervening public records requests. Yes?
A lot of our board meetings are actually recorded by SLCT. We've tried to encourage people to use this room so that we can have them recorded, so those don't get thrown away. SLCT does keep them for us, but you could use that as well as the audio assistant as far as revisiting the meeting.
That's correct. There's no requirement that the assistant make an audio recording. So, if they are able to do it by just taking notes or watching the video on the TV afterwards, that's fine. There's no requirement that you make a recording. It's just that if you do, in that small window of time, that recording could be a public record.
So the same thing goes if SMLT is making the video recording, someone can use it for creating the minutes. But once the minutes are created, that recording is no longer needed, or its retention is up to the TV folks. It's not up to the specific board to keep the video of that meeting.
That's correct, and I'll be honest, I don't know to what extent SLTV is a public body. I know that it's sort of quasi-public, it's a private corporation, but it's funded with public money. So I would leave it up to them to determine, what the retention schedule is for those recordings and to what extent they're public records. I, for one, greatly appreciate having those recordings, because if I get involved in litigation or something of that nature, I can go back and I can, review those meetings, and sometimes it's very helpful to be able to see them.
Lynn Shepherd, I have a question.
Yes.
If the Finance Committee were to discuss a 5-year capital plan, or even in your case, articles for the next town meeting, would we have to post the 5-year plan document along with the minutes?
So the rule on documents is that, first of all, so the 5-year capital plan is a public record once it's discussed at a meeting. However, if the document is also used at the meeting, then it becomes part of the record of that meeting. And so the idea is that if the document is physically present and verbally identified and the content is discussed, then that's considered an exhibit to the meeting minutes and has to be maintained as such.
Okay, and in the case where if we were discussing articles for the next town meeting, would we have to have a copy of those articles that, in whatever form they were prior to the actual town meeting attached?
Well, so you don't have to have that, but if you do have it and you discuss it, then it becomes part of the record.
Okay. Well, in your example, you referenced specific articles by number, so I assume they're on some kind of document, right?
I would imagine for practical purposes, in that example, it would be on some sort of document. Yes, Maureen?
Articles are not really prepared until after the discussions with the finance board. So it's not like they start their season with, okay, this is going to be Article 1, this is going to be Article 2. So those don't become concrete until we're closer to town meeting. So if they're just discussing, okay, this is what we have on capital for the next 5 years, that's all laid out, and that's usually part of, attached to the minutes, etc. But nothing in that is concrete until we actually put the warrant together. So, I just don't want to see people have to do more for less.
Right, and so I don't think that you're required to create any more documents than you already are, right? And so I think it's just a matter of, if you have a draft, let's say you have a draft FY22 capital plan, okay? And the Finance Committee talks about that at their meeting. Then if somebody comes in and requests a copy of that plan and it already exists, then it's a public record and it's subject to disclosure. And because it was used at a meeting, then it's also subject to the retention schedule for minutes as opposed to other types of public records. But there's nothing here that's requiring you to create a document that you didn't already create. Okay?
If
Yes.
I could just say something, the Capital Budget Committee, when
Who are you?
Everett Heller,
Finance.
I'm the chairman of that committee.
Okay.
If we do, that's kind of an ongoing document. We don't attach every copy of it to our minutes. However, because it's a fluid thing that doesn't get wrapped up until right before the end of the town meeting. But it's definitely available. We do pass them out if people come by.
Okay.
So, but I would imagine that it didn't have to be attached every single meeting, those have to be attached, and the omnibus budget has to be attached. I mean, that would just become so cumbersome that it'd be a full-time job.
Yeah, no, that's not what's required. But by the same token, if you had a document in front of you that's version 1, and you sat it at the table and went through version 1, and then at your next meeting there was a version 2, both version 1 and version 2 are public records.
What we do is we date and time stamp
Yep.
each one so that you can follow the track if you like.
And in my opinion, that's acceptable. And, to say that it's part of the minutes, I think is somewhat confusing because it doesn't require that it be kept in a drawer together with the minutes. It's just that if there's a request, you have to be able to cross-reference. So it's not like you need to have 50 versions of this document in 50 different places, okay? Yes, also in the back?
Elaine Heller, and I am the recording secretary for the Finance Committee.
Okay.
I keep a copy of everything I get with my draft minutes, and I keep that forever. And that's enough. Those copies do not have to be attached to the minutes that are posted, is that correct? As long as you have a hard copy, it doesn't need to be posted electronically.
That's correct.
And I do have a copy of each and every thing we get at a meeting.
Okay, good. Was there a question over the phone?
May I ask a question?
Yes.
Okay, this is Lex Thomas. Greg, when you're talking about meeting minutes, most of our minutes are taken by volunteers who do their very, very best job, but I'm questioning about what goes into the minutes and their validity when you start to try to hold this up in a legal process or even in just our just town records. And this for me has been problematic. So how do we deal with that? Because when you're talking about minutes, it's not like in a legal office when you have, your paralegals and people who really know how to do minutes. That it's a skill.
Well, sure, and certainly most people here are volunteers, and everyone's doing the best they can. But what you want to do is try to capture a short summary of what was discussed. And these meetings do have to be approved by the members of the board, and so certainly the members of the board can say, well, I'd like this portion of the discussion to be reflected in the minutes, or I don't think that this summary quite accurately captures it. I think it should be said like this.
Okay, but Greg, that doesn't tend to happen and I'm a consultant, and so I'm really on the outside of this, but I just sort of see people nodding a lot and saying, okay, let's approve these minutes, but I think what I'm trying to say is I think that the importance of minutes is not adequately appreciated and reflected. And that's my entire comment. Thank you for letting me speak.
Sure, no problem. So
I have a question.
yes.
This is Roseanne Mapp. If you're in a meeting and there's a guest who comes to the meeting or a consultant, such as Lex Thomas, and she gives a presentation, what are the requirements about providing in the meeting minutes that presentation as a document? Thank you.
So if the document is actually displayed at the meeting, then it's part of the record. And the minutes should reflect that. On the issue of the budget, whatever, Lex Thomas, a consultant gave a presentation by showing a PowerPoint to the members who were present, and then a very short summary of what that entailed.
You don't have to attach the PowerPoint?
So again, the PowerPoint is a public record at that point, and it's part of the record, but it does not have to be physically attached to the minutes.
Well, if I can interject here, whenever I have done a presentation, I have also done, my documentation. I guess what I'm really questioning here is just making sure that minutes really reflect, the concerns of people, so that I'm sorry, I'm not expressing myself very well, but it's just, when you have a presentation or whatever, I just want to think that people that are getting them the minutes are getting a very accurate view of what is being voted on. And as a consultant, and I realize here, I'm not trying to dig my own grave here, but I think that people need to know what they're getting into.
Okay.
Can I ask a question? This is Lynn Shepherd again. So on the case where there was a PowerPoint, you say it's part of the public record, so if somebody requests that PowerPoint, it has to be available to send to them, correct?
Correct.
Yeah.
So, but there's no requirement to store that PowerPoint online on the town website the way the minutes are stored.
That's correct.
So the town clerk maybe has these and would know that if somebody requested the PowerPoint presented at meeting held on such and such a date, they would have a way to pull that out and provide that?
Well, yeah, so, we're gonna get to this a little bit later, but, the town clerk is the records access officer, and, a public records request is going to come in, and, let's say this was a meeting of the planning board, and it, requests a copy of the PowerPoint presentation shown at the July 1st planning board meeting. It's then incumbent on the town clerk to go to the planning board's clerk and ask for a copy of that document so that it can be sent to the requester.
The town clerk wouldn't necessarily have those documents, but as the records control officer, she takes the request and go finds the person who does have it.
That's correct. The
So
town
it's
clerk doesn't have to have everybody's documents in her office. She just has to be able to get them.
Okay, are we
Excuse me.
moving
This
on?
is Roseanne Mapp again. In the case of a consultant who is performing a presentation on their own, should that consultant provide the town a copy of that presentation? And how should that also be included in, how would you include that in the meeting minutes?
It's up to the consultant what they.
Yeah, I mean, there's not a universal answer to that particular question. It depends on the circumstances. But again, if there's a specific document that's used in the meeting, it's a public record and it has to be maintained as a public record, which does not necessarily mean in the same exact location as the minutes.
Okay.
Can we move on?
I have a question.
Yes.
I'm gonna have been on you.
Hi, go ahead, do you have a question?
Is that Rob?
Yeah.
I think he's on mute still.
Well, he can,
No, they were on live, but now they're on mute.
Okay.
Rob can unmute himself if he wants to. Let's see where.
Can you hear me now?
Yeah.
Yes.
All right. This is in reference to the planning board. This is in reference to the minutes. There is nothing wrong, or there is nothing saying we can't have a recording, video and audio recording of the minutes or the meeting. I should say the meeting, not minutes. In addition, they have the written minutes done by our recording secretary. In other words, if the Sterling TV wanted to produce audio and visual CDs for us and we became the stewards of those CDs, there is nothing saying we can't do that. Is that correct?
Well, I mean, so if you're a member of the board and you're recording the meeting, yes, you can do that, subject to the rule that you make an announcement to everyone present that you're recording the meeting. And then that recording is a public record and needs to be available upon request, because a public record is any record made or received by a public official. So if you're a board member and you're taking it upon yourself to record the meeting, then that meeting recording becomes a public record.
But I'm being dependent on the Sterling television to do the recording, but handing us the CD for us to become the stewards of it to save it.
No, I mean,
Same as you say that you like to fall back on a recording when it comes to a case that you're doing. We would be able to refer back to that particular meeting whenever we wanted to.
well, sure, so, I mean, the recordings that are made by the Public Access Corp are their recordings, and, you know, if they want to provide copies of those recordings to town officials or members of the public, they can do that, and then, you know, that's up to them. I mean, I don't think there's anything that would prevent you from receiving that. However, if you're receiving it on behalf of the town, then it's a public record, and it has to be kept in a proper way that public records are kept, which means at town hall.
Everybody's got
That's fine.
files. Everybody has file cabinets.
Okay,
I can't hear the comment.
I said everybody's got a file cabinet, Bob.
okay, we need to move along. There are people that are waiting for us to move along.
Okay. All right, so,
I can try to, she can wrap up in a half an hour.
okay. So I guess then, before we move on to public records, are there any other questions about public meetings? All right, so since we've already started to talk about this, why don't we start talking about public records? And public records, again, is any book, paper, map, photograph, recorded tape, financial statement, statistical tabulation, or other documentary material or data, regardless of physical form or characteristic, made or received by any officer or employee of the town. So what that means is that every time you receive a piece of paper, an email, a text message, the content of those messages are public records and must be retained as such. It does not, the medium that it's received in does not determine whether or not it's a public record, it's the content. And so if you receive a text message on your personal cell phone regarding a matter of public business, that text message becomes a public record the moment that you receive or create it. Same thing with emails or social media posts, as well as physical documents, other recorded media, videotapes, CDs, etc. And so it also doesn't matter whether you are a paid employee or a volunteer. Any records that you use or create as part of your official town business are considered public records. So, you know, we typically recommend that if the town provides you with an email address, that you use that email address as your sole means of communication for the town, that you do not use your personal email or your personal cell phone to do official communications on behalf of the town. If you do, however, you need to be prepared that if there is a public records request, then you may be called upon to turn those records over. In terms of a public records request can be made in person or in writing, either in email, at the counter of the town hall, or by fax. It can be made to the records access officer, who is the town clerk, or it can be made to a specific public official. If it is made to a specific public official, it's recommended that the request be turned over for tracking by the records access officer. Once a public records request is received, you have 10 business days to respond. That's 10 business days. That means we don't count Saturdays, Sundays, legal holidays. However, you do count days that town hall is closed, unless those days are Saturdays, Sundays, or legal holidays. Within that first 10 business days, you have to provide at least an initial response to the requester in writing. That initial response can either be copies of the records themselves or a good faith estimate of when the records will be provided. You can assess a fee in exchange for the time that it takes you to search and search for the documents. You can also charge a fee with respect to providing paper copies of documents or your actual cost of providing physical media. So if you have to provide some type of storage device like a thumb drive or a CD, you can assess your actual cost in obtaining that media. However, with respect to copies, it's suggested that all records requests be responded to by providing digital copies, unless the person specifically asks for paper copies. If you're maintaining minutes or other records on the town's website, it's acceptable to refer the requester to the website. So a lot of towns now have their annual reports on the website, their meeting minutes, the agendas, other types of records and reports, warrants. If any of those things are on the website, then you can refer the person to the website. If within that first 10 business days you cannot fully respond to the request, then you can have an additional 15 business days to formally respond. But in that first 10 days, you have to acknowledge receipt of the request, identify the person or persons who have the documents, identify whether or not documents are expected to be produced, and whether or not any exemptions may be asserted. You can also give a good faith estimate of the cost that it's going to take. With respect to the time to search, you can charge up to $25 per hour based on the salary of the lowest paid person capable of doing the work. And you can provide an estimate for that, and you do not have to begin doing the work until you receive the payment of that estimate. Okay. So any questions about how to respond to a public records request, at least that initial response? If you cannot respond within this total of 25 business days, you can request additional time from the supervisor of public records. The requester can also agree to give you more time to respond, but if you have such an agreement, you should get that agreement in writing. Okay. So some of the commonly used exemptions are Exemption A allows you to withhold documents that are specifically exempt by statute, such as records that are protected by QUARI, domestic violence reports, student records, MCAD documents, or abatement applications. Under Exemption C, any personnel or medical records or other records which would unreasonably interfere with a person's right of privacy. Exemption D are deliberative process documents, are those between governments on matters for which policy positions are still being developed, including legal advice. Exemption E, personal notes that are not properly part of the file and that have not been shared. Exemption F, records of ongoing investigations until the investigation is complete. Exhibit N, infrastructure exemption that are likely to jeopardize public safety. Exemption O, personal email addresses, home addresses, and home telephone numbers of public employees where they are characterized as such. So any questions as to what constitutes a public records, the procedure for responding to requests, or what types of documents may be withheld?
I just
Yes,
want to
Ross.
interject that any board or committee or individual that receives a public records request should forward a copy of that immediately to the town clerk, because as records control officer, she needs to track this. You may still have to provide the information, but be sure the town clerk is aware of this so that she can be tracking this.
Yes, and it's important because, as we'll see in a minute, someone who is not satisfied with your response to a records request, if you don't respond within that initial 10 days, you lose the ability to charge any fees. And if a person chooses to go to court to compel you to produce public records, and they are successful, there's a presumption in the law that the town will have to pay their attorney's fees for going to court. So there can be potentially severe consequences to the town for not properly responding to a public records request. And so it is very important that these things be closely tracked by the town clerk's office. So as I said, there is an appeal option. There can be an appeal to the supervisor of public records or to the Superior Court, and the Attorney General can issue orders to comply. With respect to actually producing the records, as I said before, there's an electronic, a preference to produce records electronically if you are able to do so. And it's also encouraged that wherever feasible, that you put documents on the town's website. So anything like, final decisions, opinions, orders or votes, annual reports, notices of hearings, winning bids for public contracts, awards of federal, state, or municipal grants, budgets, and any other documents that might be of significant public interest. Again, the more that you can put on the website, the easier it's going to be for you in order to be able to respond to records requests. Some best practices, again, use your town email account for conducting town business. If you do receive or create records outside of town hall, you should bring them in for storage. Again, make sure that when you're using email or text messages that, you use a formal, professional tone, because these things are going to be subject to request. So any questions regarding public records? And I know I covered this quickly, so, if things come up, you can go through Ross and we can cover things in more detail. So let's talk about the conflict of interest law a little bit. So the conflict of interest law determines basically the standards of ethical conduct for municipal employees. A municipal employee, again, is any person who performs a service or holds an office, position, employment, or membership in a municipal agency, whether by election, appointment, contract of hire, or engagement, whether serving with or without compensation on a full or regular, part-time, intermittent, or consulting basis, but excluding elected members of town meeting, which you don't have, or members of a charter commission, which you don't have. So essentially, any person who does work for the town, whether they're paid or not, is subject to the state's conflict of interest law. And there are 4 general categories of things that you need to be concerned about. Section 17 deals with agency and limits your ability to act as an agent for an entity or person other than the municipality. Section 19 deals with financial interests and prohibits you from participating in a matter in which you, your employer or immediate family member has a financial interest. Section 20 limits your ability to have multiple contracts with the town or a second paid position except under limited circumstance. And Section 23 is a code of conduct which prohibits you from participating in matter that may affect your ability to act in the town's best interests. Okay, so there is also a category called special municipal employee. This is a designation that is granted by the Board of Selectmen. It is granted not for people, but for positions. So, for example, if the Board of Health's assistant is designated as a special municipal employee, that designation is given to any person who holds the position of Board of Health assistant, provided that the position is either unpaid or is part-time up to 800 hours per year. Yes?
Elaine Keller, again, I do the finance committee under the senior work-off program, but I also work part-time, very limited hours for the Board of Health.
Okay.
Does that mean that I can't have the two positions?
So, again, if one of those positions is designated as a special municipal employee position, then you can hold multiple positions. So you should check with Ross to make sure that you're fully covered in that respect.
Thank you.
Okay? Other key definitions: immediate family is the municipal employee, the employee's spouse, and each of the employees and the spouse's parents, children, brothers, and sisters. And so this is a very specific definition. So oftentimes we'll get a question, well, my best friend who I've known my whole life and was the best man at my wedding is going to be appearing before the planning board for site plan approval. Do I have to recuse myself? And the answer is technically no. As long as you can, perform your duties in a way that is impartial and you treat this person the way you would anyone else, you can continue to participate because they are not one of these specifically defined relationships. In addition to certain restrictions on financial conduct, there's this code of conduct, and in particular, Section 23B3 states that a municipal employee may not act in a manner which would cause a reasonable person having knowledge of the relevant circumstances to conclude that the employee is acting with bias, favoritism, or other personal reasons. So this is a circumstance where the best man at your wedding comes in front of you for a permit. A reasonable person might think you would give them special treatment. In that case, however, if you publicly disclose the relationship and go on record as saying that it will not affect your impartiality, you can still participate in the matter as long as you're comfortable in doing so. In addition to taking actions that would give rise to an appearance of conflicts, there are significant limitations on your ability to accept gifts or anything of value. In terms of acting as agent, you cannot represent another person or organizations in their dealings with the town. So almost any instance in which you're a municipal employee, you are prohibited from acting on behalf of someone else who is contracting or communicating with a town office, acting as a liaison with a private party, providing documents to a town office, or serving as their spokesperson for a town authority. However, you can always act on behalf of yourself. So with respect to financial interests, a municipal employee may not participate in their official capacity in any matter in which they or their immediate family member or their private business or employer has a financial interest, regardless of the size of the financial interest. However, Appointed officials can obtain an exemption from this by making a disclosure to their appointing authority. And you should also note that financial interest specifically includes abutters and abutters to abutters within 300 feet of the property. So financial interest contracts, section 20 prohibits you from having a financial interest in a contract with the town. This includes a second office if it is paid unless you qualify for an exemption. Some of those exemptions are the contract. If you're a regular employee, the contract is with a different department. The contract is made after public notice. The employee files a written disclosure, and the contract is for personal services such as a second town position, must be outside your normal hours of primary position, no more than $500 per year, and the Board of Selectmen votes to approve. Okay. So, this was a very, again, cursory review of many of these materials, but hopefully, this was helpful to you in understanding, what some of the things are that you can and cannot do. We have additional resources on our website, and, if there are questions about specific circumstances, feel free to go through Ross, and he can forward those inquiries on to me.
Now, is this online? This little so-called sunshine laws?
It will be tomorrow.
Okay. Just so everybody knows, especially those people at home, this document can be accessed sometime tomorrow online. Want some hard copies, somebody will make you some. Greg, why don't you take a couple for the other people on your board?
Okay, I will.
Because you have a meeting, right?
Yeah, tomorrow.
Yeah. So,
Just have one question.
Yes.
When somebody recuses themselves from a meeting, do they have to let you know, not specifically, but the general idea why they're recusing themselves? Or can they just say, I'm recusing myself and walk away?
They can recuse themselves for any reason, and they do not have to explain. Actually, this gets into one of the things that, Ross, you did ask me to cover, so I'll cover it quickly. So if someone has a conflict that prevents them from participating in a matter, they do have to recuse themselves. They have to leave the table, but they do not necessarily have to leave the room. They can sit in the audience to the same extent that...
What a great choice.
No, it's
I love the guy.
take your time, Everett.
And it's spam to boot.
So they can continue to sit in the audience, they just cannot participate in the meeting as a public official. And recusing yourself does mean completely recusing yourself. You can't speak, you can't vote, you can't participate in the matter in any way. With respect to the so-called rule of necessity, what this does is this allows a board that is prevented from reaching a quorum by reason of conflict from waiving the conflict for one or more of the members. But it is very specific, so that, let's say you're a 3-member board and one member has a conflict and one member is absent, you cannot invoke the rule of necessity because you can still achieve a quorum without the conflict. Even if that third seat is vacant, you still cannot invoke the rule of necessity. You have to fill the vacant seat in order to act. It's only when the conflict itself prevents you from achieving a quorum. So if 2 out of 3 members of a board have a conflict that prohibits them from participating, then you can invoke the rule of necessity and allow those members to participate.
And I have one other COVID
Sure.
question. So if the governor is allowing people to participate remotely and they don't have to fill out the Mullins, even if other members are here?
I'm sorry, I didn't hear the whole thing.
Sorry, if one of the members is going to be participating remotely, and other members are going to be here physically, do they have to do a Mullins, or do we have to do any kind of special vote for somebody to participate remotely?
No, for purpose of Mullins, so the Mullins rule is that if a person misses a session of a public meeting, right, they're not allowed to vote. But if they're participating remotely, then they would not be considered to be missing the meeting. Under the governor's orders, members who are participating remotely are full members and are fully participating. Okay? Any other last questions?
Greg, thank you very much for coming out.
Oh, you're very welcome.
And to everybody that's here in this room and on video, thank you for showing up tonight. I realize this is a long night, but we've had over 51, I think, remote participants. I think that's very good. So
Great, thank you, everyone.
thank you, everybody, for showing up tonight.
Thank you, everybody.
Thank you.